Chapter 15. Economic Regulation and Antitrust Activity. Market power is the ability of one or more firms to maintain a price above the competitive level. Government regulation of business. Social regulation, government measures aimed at improving health and safety. Economic regulation, government measures aimed at controlling prices, output, market entry and exit, and product quality in situations in which, because of economies of scale, average production costs are lowest when the market is served by only one or a few firms. Antitrust activity, government activity aimed at preventing monopoly and fostering competition. The figure shows regulating natural monopolies. Special interests. Well-organized producer groups may profit from economic regulation and are able to persuade public officials to impose the restrictions existing producers find attractive, such as limiting entry into the industry or preventing competition among existing firms. Producers have a strong interest in matters that affect their specialized source of income, so they play a disproportionately large role in trying to influence such legislation. Interstate Commerce Commission, ICC, and ground transportation. The ICC was established in 1887 to regulate the railroads. Early on, the ICC actually protected railroads from competition among themselves. In the 1930s, the ICC began to regulate trucking as well. The Motor Carriers Act of 1980 deregulated the trucking industry and restored vigorous competition in the market for ground transportation. The Civil Aeronautics Board, CAB, and airline deregulation. CAB, established in 1938, regulated the domestic airline industry, primarily to the benefit of existing airlines. The Airline Deregulation Act of 1978 eliminated virtually all economic regulations on the industry, causing the industry to restructure itself along lines that were highly competitive. Remaining duties of the CAB were transferred to the Federal Aviation Administration. Antitrust laws. Sherman Antitrust Act of 1890. Per se, illegality, business practices that are deemed illegal regardless of their economic rationale or their consequences. Under the Sherman Act, price-fixing schemes are viewed as illegal per se. Rule of reason used by a court to examine the reasons for certain business practices and their effects on competition before ruling on legality. Under the Sherman Act, not all monopolies are illegal, only those which obtained monopoly power using abusive strategies, such as predatory pricing. Predatory pricing. Pricing tactics employed by a dominant firm to drive competitors out of business, such as temporarily selling below cost and dropping the price only in certain markets. Consent decree. A legal agreement through which the accused party, without admitting guilt, agrees to refrain in the future from certain illegal activity if the government drops the charges. Clayton Act of 1914. Price discrimination. Tying contracts, an arrangement in which a seller of one good requires buyers to purchase other goods as well. Exclusive dealing, the situation that occurs when a producer prohibits customers from purchasing from other sellers. Interlocking directorate, an arrangement whereby one individual serves on the board of directors of competing firms. Concentration ratio and the Herfindahl index. Concentration ratio, a measure of the market share of the largest firms in an industry. Herfindahl index. The sum of the squared percentages of market share of all firms in an industry, a measure of the level of concentration in that industry. Problems with antitrust legislation. Too much emphasis on the competitive model. Abuse of antitrust. Growing importance of international markets.